Good morning. Welcome to the Utah Land Use Institute Seminar on Appeal Authorities. We have Duncan Murray waiting in the wings, and my name is Craig Call. I'm going to hold for just a little while we make sure all the participants are here, and then we'll start out with the just a basic bit of background information before Duncan takes over. So and appreciate your participation. We're delighted for the response to this and looking forward to the conversation about appeal authorities. So we'll be initiating that quite soon. Thanks. Well, let's go ahead with the basics. We want to remind you the webinar is being recorded, and we invite your conversation, but you will be preserved for time immemorial, and you will have the honor of being part of the conversation whenever someone has a chance to stream this conversation. We are allowing a continuing education for attorneys, but I will need your bar number. So please send the bar number to info@utahlanduse.org. info@utahlanduse.org. If you're calling on the telephone and we can't see who you are for sure, please also include in that email your name and phone number so that we know that you were the one who was attending. The seminar function on Zoom allows us to monitor the time that each connection is live, and that assures the bar that those who are getting credit did enjoy the entire 2-hour session. The materials for this session are online and can be used. Duncan will be working through those materials, and you may enjoy having them either printed on the side or on your own screen or whatever you want to do. The link is utahlanduse.org workshops. So that's utahlanduse.org. Just go to that site, click on workshops. You'll see the one for appeal authorities mentioned there, and then click on the link that says materials here. Should be intuitive for anyone who's used a computer before. One last thing to say, of course, we appreciate Duncan and all his work. You'll notice by the materials, this has been a really exhaustive review of the issue of land use authorities, appeal authorities, excuse me, and we certainly appreciate his work. We also appreciate the Department of Workforce Services. Through their Division of Housing and Community Development, we received a grant last year that allows us to pay for this kind of activity. Not much, but we did offer an honorarium to Duncan, and it also covers the administration time and the other details and the online streaming in the future. So thank you to the Division of Housing and Community Development, Department of Workforce Services. Our online library, which this will be part of, is also maintained with the support of the 1% Building Permit Fund from the Utah Department of Commerce, Office of the Property Rights Ombudsman. We certainly don't want to pass up on acknowledging them. We also thank the SJ and Jesse E. Quinney Foundation, our long-term sponsor, and Salt Lake County that provided some help for all of this. So anyway, I appreciate your attendance. We are glad you're here. And let me introduce Duncan Murray. Duncan has been around the block for a while. He's been an attorney with several local governments, has extensive experience in this, and is now serving as an assistant city attorney in West Jordan, where there's certainly a lot of land use action going on. So without getting in the way anymore, let me turn the time over to Duncan, and he will lead us through this conversation. And that's what we hope it'll be. So please use the chat function, use Q&A, and we'll try to keep track of what's going on. But one more time on that email address, I see your request, info@utahlanduse.org. I'll type it in the chat as well. Thank you, Duncan. Please go right ahead.
Okay, so I'm sharing my screen now, right, Craig?
Yes.
Okay. So the screen I'm sharing is the packet of materials that Craig Call previously has provided or will be providing to all of you as participants. Again, as Craig mentioned, I'm Duncan Murray. I am going to be going through a lot of the material that's in this PDF file. And as Craig mentioned, the subject matter of this particular presentation or seminar today is on appeal authorities. And when we're talking about appeal authorities, we're talking, of course, about land use appeal authorities. There's various types of appeal authorities for code enforcement and other matters, but today we're focused on those appeal authorities for the land use area. We're going to be going through some definitions to explain that a little further. There are 4 sets of materials that you'll notice that you have in the packet. First of all, there are some provisions of the Utah Code, Land Use Development Management Act. I'm going to gradually scroll down my screen. And and those are just selected portions of LUDMA is what we call it, regarding appeal authorities, together with some questions and practice points. There's a part 2 dealing with some property rights ombudsman opinions. There's a part 3 of the materials talking about a couple of Court of Appeals opinions with some practice points, and then an appendix dealing with some selected West Jordan City Code provisions. And we may or may not cover some or all of these materials. I just wanted to let you know what's available as you continue to look at these materials after the presentation today. I would probably start off by saying appeal authority law is one that's primarily statutory, primarily in state law. And that's why it's important to know what's in state law and to especially know the definitions. A lot of that state law allows for flexibility and for discretion at the local municipality, city or town level or county level, and in how you set up the appeal authorities and rules and so forth. The presentation materials, you'll notice I've referring primarily to municipality, from a municipality point of view. So we're using what's called city LUDMA citations, which are found in Title 10, Chapter 9A of the state code. If you work for a county and you're using what we call county LUDMA, most of the provisions are identical or very close, and they're found in Title 17, Chapter 27A. So you could find the equivalent sections in county LUDMA if necessary. I know today we do have a lot of people that are here that work for cities, maybe city planners and engineers, city attorneys. We probably have a lot that are the same type functions working for counties. And invariably, there's a lot of you that are real estate or development professionals or attorneys that work with them, or landowners, or in some other similar capacity. So I hope that everything today, that you feel free to ask questions, and hopefully everything's a benefit to you from your perspective and point of view and what you're looking to learn more about. The materials are designed to allow you to work through them regardless of your level of experience or expertise. We are going to start more at a basic level, and hopefully those of you that have a higher level of expertise can just kind of be patient and hang with us while we build that foundation. And likewise, as we get into some of the ombudsman opinions and appellate cases, some of you that are maybe newer to appeal authorities, maybe you can kind of just glean as much as you can during that time period, soak in as much as you can, so to speak. All right, with that, if there's no questions right off the bat, and feel free to ask questions at any point, we'll just jump right into the LUDMA, the statutory material. One of the very first definitions in LUDMA, because it's alphabetical, is the definition for appeal authority. And it means a person, board, commission, or other designated by ordinance to decide an appeal of a land use decision of a land use application or a variance. And we don't need to go through all these questions necessarily today, but I encourage you, especially if you're new, to do so later. But as these questions intimate that an appeal authority can be one person. I've acted as a one-person appeal authority for a couple of small towns over time. It can be a more typical one, 3 to 5 members. It could be 9 members. Literally, the key here is it's as designated by ordinance, by the city council or equivalent body, by ordinance, how it's set up by the entity. You can, as far as membership, as far as there is no default number of members. It literally is just how it's designated, but it has to be by ordinance. And the purpose of that appeal authority then is to decide appeals of land use decisions and also variances. A variance, as we'll talk about later, is a very specific type of land use appeal, and you're pretty much appealing the land use regulations, city code or ordinance, as opposed to an actual land use decision made by a member of city staff, a planning commission, or other land use authority. 2 distinct types of appeals. We're mainly focused today on those types of appeals of actual land use authorities, as opposed to variances. And then some of these questions towards the end of the list. Does a municipality have to call its appeal authority a board of adjustment? To which the answer is no. That in the past, that has been a very common name for an appeal authority. However, it could just be simply appeal authority. It could be administrative law judge. It could be hearing officer. It could be whatever, again, the city or other entity designates by ordinance or whatever their equivalent procedure is. And so the practice point there is make sure that your municipal or county council adopts by ordinance the rules regarding the number of members and the name of your appeal authority. And keep in mind that you might flesh out additional rules in another method other than by ordinance. If the ordinance allows the mayor, the appeal authority itself to adopt additional rules that are not inconsistent with the ordinance, that's also possible. But those main provisions, as far as the number of members and the name and so forth, should be fleshed out in your ordinance rather than your rules of procedure or bylaws. Any questions so far? Okay, and since that since that rule, that main definition of land use or of appeal authority mentions that it's people can appeal the decisions of that land use applicants can appeal the decisions of land use authorities. We need to kind of next identify what is a land use applicant, or who is one. And primarily it's as the, and again, these are the definitions right out of state law, right out of LUDMA. This is the 28th definition in that definition section. Land use application, first and foremost, as a property owner, right? But it could also be somebody the property owner designates on his or her behalf that submits that land use application regarding that property owner's land. And so a very important question here is, can an applicant be someone other than the property owner? And to which the answer is yes, right, as we've mentioned here. But a very important provision, or a very important practice point here is to make sure, if it's somebody other than the property owner, that you have some methodology for identifying that they are in fact empowered to act upon or act in behalf of the property owner. I was working for a city years ago, and we were trying to work with landowners or developers on opposite sides of a major street. The city wanted to line up the key access roads so it would make a four-way intersection. So we entered into kind of a verbal agreement of sorts between the city and the two developers that they would line up their roads. We had applications for subdivisions showing those roads lining up. One of those was owned by that was acting on behalf of himself as the property owner. The other one had someone else acting on his behalf. The city failed to obtain a property owner affidavit from the second owner, and the ownership somehow changed, and the new owner did not want to line up the intersection, and we ended up with an ombudsman opinion, and we'll talk more about what those are later. But basically telling the city that since we had failed to obtain that owner's affidavit or other method requiring that the second owner line up, we were not able to line up. Since that point in time, of course, I've been very focused on making sure that we always have owner's affidavits proving that someone, as part of the application process, that someone is empowered to act on their behalf. Or if there's a new owner, that we make sure we get the new owner involved. So as the practice point says there, make sure you have a property owner's affidavit or some other method to document authority if you're not dealing directly with the property owner, especially during your application process. And then, of course,
yeah, go ahead. Just a really quick question, Duncan. Probably important to note that it's not just the land use applicant who brings an appeal to the appeal authority. For example, a neighbor might bring an appeal. Under Utah law, any administrative decision at all, even if it's not defined as a land use decision, has to go through some kind of administrative appeal process before they can go to district court. It's required. And so we had a recent case down in San Juan County where the neighbors of a wind farm brought a land use complaint or issue to the San Juan Planning Commission. And the Supreme Court's heard this case twice, but the issue, I mean, these folks brought this matter. They were neighboring landowners. They weren't the owner of the wind farm, but they certainly went through an exhaustive process and are still going through it. In fact, this case makes me understand how the lawyers use the term exhaustion for the duty to make sure your local remedies are taken care of. But an appeal must be filed before you get district court on anything except a legislative land use enactment. And so we may have time to talk about standing when we get into the real minutiae here, but I just wanted to mention that it isn't just the land use applicant. It often is. In fact, I would say, wouldn't you say, Duncan, the majority of the time it's the land use applicant who has an issue with a decision?
It is. And like you say, it can be nearby interested landowners. There's a variety of different parties that appeal, right? It's not just the ones that intuitively you would think appeal. And but that is a key point, is exhausting those administrative remedies, because otherwise you can't preserve your right to go to court. So the next definition is land use application. Just what is it? But it's whatever's required by the municipality, submitted by a land use applicant to obtain a land use decision. It could be from anyone, right? For any purpose. Could be a building permit, could be a application for a subdivision, site plan, conditional use permit. That's a land use application, but it's not, as Craig just mentioned, a legislative process to enact, amend, or repeal a land use regulation, like an ordinance, a zoning map amendment, if you will. That's a different process, and that cannot be appealed to anywhere other than district court, right? That's the appeal mechanism there. So those questions, you can kind of see them. As a question 20 there, as a general rule, is the land use applicant entitled to a positive land use decision by the land use authority, which would be like your planning commission, could be a member of your staff, depending on the case, if his land use application complies with all the requirements of the municipality's land use regulations in effect at that time. And those are two key sections. I didn't actually put them in your materials because they're not part of the appeal process. But 109A 509 or 109A 509.5 are the equivalent sections in County LEDMA, are ones you really want to know, because those are the ones that basically mention this principle, that the land use process is quite often just very ministerial. You check boxes off the list, and if the applicant meets all the requirements of your code, two things happen. One is they're essentially vested at that point. And secondly, the land use authority should feel compelled to grant the application if they meet all the requirements of the land use regulations in effect at that point in time when they filed the application. Very important part of land use law. And then, of course, the question 21 is important then. Is the land use application process administrative or legislative? It's administrative, right? As opposed to when a city or county council or a county commission, when they enact, amend, or repeal a land use regulation, that's legislative. Basically, one process creates the rules and the other process administers the rules, right? All right. And so the practice points there that you'll notice, and it looks like Wilf will chime in a sec, are to make sure that each land use application is for specific permits or other type of application for a specific use allowed in the zone. And what I meant by that practice point is that sometimes we forget to make sure, depending on the zone that the proposed use is in, to make sure that it's either a permitted or conditional use allowed in the zone as set up by the city or county council. And that's one of the key things the city staff and planning commission or land use authorities need to verify. Yeah, Wilf.
Sorry to interrupt. I just wanted to jump back on when you were talking about the appeal process being for administrative only and not legislative. There is, so to speak, an appeal process on the legislative side, and it's called the referendum, which is a whole different process and ball of wax, requiring collecting citizen signatures and getting it on the ballot and so on. But those legislative decisions can be appealed, I guess you would call it that way, through the referendum. but all the administrative ones go through this administrative appeal process.
Thanks for that clarification, Wilf. So in a sense, you've got two options, right, for appeal of a legislative decision. One is the referendum process that Wilf was just talking about. Another one is within 30 days, going to district court to have a district court judge appeal it that way. So then another basic term, land use authority, and you potentially have multiple land use authorities. Sometimes it's your building official or building inspector. Sometimes it's your planning commission acting as a land use authority on subdivisions, site plans, conditional use permits, that type of thing. It could be a variety of different people in different circumstances. As sometimes it is a local legislative body, which is problematic if you live in or if you work in a city that's a strong mayor council, or strong mayor form of government, which is mayor council form. That's something to be careful of. 90% of our municipalities are the regular traditional council form of government, which this is possible if it's done properly. But it's interesting that the default in LUDMA here on 30B is that if the local legislative body has not designated by ordinance, then it's the legislative body itself that acts as the so it acts as the appeal, or as the land use authority. So, which is interesting then, because they're both creating the rules and administering or acting on the rules, right? If they're the local, if they're the by default or either by design, if they're the land use authority. And so that's what I mentioned there in question 27. The automatic default is for the land use authority is the council. I think I've rarely seen that. Most cities have a planning commission and place a lot of the land use authority in the hands of the planning commission, or sometimes individual staff members. And as with the appeal authority, a land use authority, as it mentions there, or at least questions there in 24, can be one individual. So what would be good as a practice point is to make sure you know who your municipality or county is designated, whether it's the planning commission staff or somebody else, as the land use authority for certain types of applications for each type. And then if that designation hasn't occurred, make sure that by ordinance your council does designate that. And of course, usually the rules and the names of the land use authorities put that right in code as well. And again, just like with appeal authorities, land use authorities can also, if allowed by ordinance, flesh out some of their own rules by bylaws or rules of procedure. And definition 31, land use decision, then, is any administrative decision that a land use authority or appeal authority makes regarding a land use permit or a land use application. Those are what we call land use decisions. And the way this used to read before, and of course this definition has changed a lot in the last few years, but right before May 4th of 2022, you can see how it read. It also included the enforcement of a land use regulation. Since then, it does not include that anymore. There's another section we're going to be looking at, 10.9A 802, which talks about code enforcement and code enforcement appeals, which arguably is, at least currently under this definition, a separate process from the land use appeal authority process of actual decisions. Now we have kind of a separate under 10.9A 802, a separate enforcement area, which presumably you can still have an appeal authority. And not only could have, presumably should have, because Craig Call always cites a case called Patterson versus American Fork. And the ruling appears to, the state Supreme Court appears to insist on exhausting those administrative remedies, using them up, as we were just talking about, with code enforcement cases, in addition to the appeal authority cases, but also in code enforcement cases. Did you want to chime in?
Let me chime in. This case is remarkable. Patterson, a contractor in American Fork, was so frustrated with the city that he charged 27 separate causes of action in a case against the city. And he went from the Constitution all the way down to the, local enforcement review. And the opinion was authored by Christine Durham, who at the time, I believe, was the Chief Justice of the Utah Supreme Court. And this is a great case involving constitutional issues, basically saying that if you want to raise a constitutional equal protection argument before in a land use context, you had better be talking about racial animus. I mean, the opinion was so sweeping that basically what she said was all 27 causes of action, every single thing he argued, consistency of reviewing the plans, arbitrary decisions, conflicts of interest, due process, everything was dismissed because there had been no local review. And I'm not sure the court quite grasped the process, because the opinion says, well, they could have gone to the planning commission or something. But the bottom line is there has to be a local administrative review before you go to district court if it's an administrative issue. And the concern is that this recent change in the definition by the legislature might lead someone to believe that because enforcement's not in the definition anymore, that either A, the appeal authority can't hear an enforcement, or that you don't need an appeal on an enforcement. And I'm not sure either one is true, but I think it's a little messy. The problem is that someone goes to district court without that review and then is kicked out. Unfortunately, the court says, I don't have any jurisdiction because you haven't done your local appeal. And guess what? The time to file a local appeal passed while you were fiddling around at district court. So it's, I think the legislature's created a bit of a minefield here, but just to make sure, the only way to be sure that people's interests are protected, whoever has to file the appeal, is that there has to be a local appeal process, or a person does both, file in district court and file a local appeal at the same time, put the district court action on hold, don't serve the other party or something, so that all these rights are appealed. Because I think we really have an interesting dilemma in what difference it makes that the legislature changed the definition of a land use decision, for what it's worth.
Yeah, no, I appreciate that. And that's kind of a segue to my next thought, is that we've talked, you just talked, Craig, about what are the best practices if you're in that situation of having to appeal an enforcement action by a city, or to file some kind of code enforcement appeal. I always then think about, from the other perspective, how do we, even though we've got the provisions in the state code that we have, what can cities and counties do as practitioners to mitigate the potential for those types of fact patterns? What can we do with our city code and our city processes to obviate the potential for those kinds of things? And my thought is this, that, and especially based on what Craig just said, is that cities ought to have their own additional code enforcement process, including a code enforcement appeal process, in their city code. And they ought to have, in an ideal situation, they ought to have an appeal authority designated for those code enforcement cases. In the city of West Jordan, we have an entire title, Title 16. It's not in the materials, but we have an entire title dedicated to the code enforcement process, including code enforcement appeals. In our case, we have a one-person administrative law judge, or ALJ, that administers that title and that program. The thought that has been entertained by a lot of people is, if you have those two separate processes, the appeal authority process for land use decisions that we've been talking about, set up in your code under state law, and if you have a separate process for code enforcement set up in your city code or ordinances, and if each was a one-person appeal authority, could that same one-person appeal authority be designated to handle both processes? And I really believe the answer to that question is yes. It could be the same person. They'd each be administering different sets of procedures and so forth. But in a way, that's one possible way of effectively, at least to a certain degree, adding back in the ability for cities to deal with enforcement actions, but in the context of a separate code enforcement appeal process under 10-9A-802, as opposed to an actual land use decision. So, and there's actually a Court of Appeals opinion you can see I've referenced there, Fuja versus Woodland Hills. And when we get there, we can talk a little bit more about it. So again, there's some questions there. Make sure you use those key sections, 509 and 509.5. And some practice points. Remember, again, land use decisions are administrative. And the enforcement of land use decision is no longer, at least at the moment, an administrative land use decision is what I should have had there. It's a separate enforcement process or decision. So then land use permits, though it is included as a land use decision when a city or county is acting on either a land use application or a land use permit. And so the simple definition of what's a land use permit, it's a permit issued by a land use authority, kind of circular, but what we want to make sure is that each time a permit is granted, it should comply with all the land use regulations. And probably another practice point I should have put there is make sure that all of your what's required by your land use regulations are actually on a checklist, and that all of your employees or those that are administering that portion of the code, whether it's a building permit technician that's receiving building permit applications that are submitted, or if it's some other technician that's receiving subdivision plats and site plan applications, make sure he or she has a checklist that includes everything that's required by state code, so that those employees or technicians can make sure that everything comes in on the initial application, and so that the other people handling that process, whether it be city planners or others, when they're determining whether that's a complete application, they can look at the checklist and the materials and verify, yep, the form's completely filled out. Yep, the fee was paid. Yes, we received this map. We got the owner's affidavit. And yes, this person is designated as the person to handle on behalf of him, and that's the person we're dealing with. Check, check, check. Because you don't want to do is be put in the process of, in the situation of approving a land use application or permit. The applicant did not comply with all the requirements because you forgot to put it on your form, or you forgot to check the checklist, and a certain amount of time has gone by, and maybe it's a zoning estoppel or some other situation where you're required to, it counts as if it was approved and it complied. And a city doesn't want to be, or a county doesn't want to be put in that situation. So we've talked a lot about administering the rules, as we mentioned, the land use regulation, that's when we're making the rules. It's a legislative decision. It's not just putting something in your city code, language or text. It's also, it could be a map, like a zoning map change. It's just the same as changing words in your city code. If you're changing a little part of a map that says that this 5 acres is now commercial instead of residential, then that zoning map changes. It's a law. It's an ordinance. It's a legislative action, or any change in a fee or anything else that governs the use or development of land. That is a land use regulation. Now, like it says here, it does specifically mention zoning maps. Could also be your land use map. Some people have a special map that's maybe even attached to your general plan that says, hey, here's our future land use designations of what we'd like zoning to be or what we're willing to consider zoning to be. Any of those specialized kinds of maps you should also adopt as a land use regulation, which means in other parts of LUDMA that are not specifically included here, land use regulations have to be adopted by first a recommendation from the Planning Commission with a public hearing, and then they go to the city or county council or commission. You're not required by state code for the city council or county commission to have a public hearing, just a public meeting. But some cities, currently West Jordan, we do by city code require a public hearing at the council level. There's pluses and minuses to that. It's a policy decision up to whatever your council wants to do. Again, it has to be, I recommend that if you make that decision to require it, maybe put it in your city code. But what a land use regulation does not include is a land use decision of a legislative body acting as a land use authority. As we mentioned, that's even a default if they don't designate. But if the city council is just looking at a subdivision plat or a site plan, they're not making the rules, they're just administering the rules. That just because they're the decision maker does not turn that necessarily into a land use regulation. Craig.
And while we're on the subject, again, the reason to make this distinction, which is essential, is that land use regulations, that is zoning ordinances, zoning amendments, zoning maps, annexations, are not appealable to the appeal authority. They go directly to the district court if there's an issue. And that distinction has to be clear, but everybody gets that. So I just thought I'd pose the question that seems to be frustrating the courts more than anything else in this arena this week. And that is a development agreement a regulation or a decision? Do you want to take that one, Duncan?
Well, for us in West Jordan, it's simple because we adopt all development agreements by ordinance. We play it safe and just determine that they are legislative decisions. We've made it that way in our city code. We've defined them that way. And so for us, it's a legislative decision, right? It's set up in our code that way. And for me, that makes sense because the types of provisions that are in development agreements are more akin to making rules than making decisions according to established rules. Because, for instance, in West Jordan, we have certain specialized zones that require a development agreement if you want to rezone to them. And they don't have as specific, fleshed out setbacks and other rules sometimes. Numerical rules that we have in traditional Euclidean zones. And so some of the rules have to be fleshed out. So there's a lot of rule making that's required. And so by definition, in my mind, the rulemaking that generally occurs. And granted, it's specific for that development, and it's not contrary to any other established provisions of the city code. City code actually allows some of that rulemaking, if you will, to occur. That is, in fact, a legislative process more specifically to that set of parcels of land than to the city, citywide situation. But so that is a question I think everybody has to jump through.
Well, and it's a quagmire. It can be quite dangerous. Development agreements have become of age, and they're really vital in many cases. A developer who gets an option on a piece of property and hopes to lock in what the rules are going to be through several phases of development. I mean, it would be legal malpractice almost for an attorney not to recommend a very well-crafted development agreement. But the reason I asked the question is in the Baker v. Carlson case, you may remember, involving the old Cottonwood Mall site in Holiday. The court ruled that part of the decision was administrative and part of it was legislative and could thus go to referendum. Right. So the development agreement was ruled administrative in that case. And the legislature specifically amended the law recently to say that development agreements can be administrative.
Mm-hmm.
So if you, I guess just a cautionary tale here, if you're involved on the city side, the developer application, whatever, if there's going to be a consideration of appeal, there has to be a decision made which you're locked into of whether or not the agreement is legislative or not. And then you're stuck with whatever you decide. And there's a lot to be said for making simple development agreements administrative. Some cities do that. They even have them done by the planning commission or even the staff. There's all kinds of flexibility. It's just that it's really important to have an attorney available who can provide some guidance when that question comes up, if it's not crystal clear what arena you're operating in.
No, that's great. Thank you. Yeah, and that ties back into Wilf's comments about referenda and that kind of thing. And a little distinction to what I said earlier, we do have specifically set forth in our city code, and we've updated it a couple of times in the last couple of years for very simplified, technically they're development agreements, but we have reimbursement agreements a lot of times if a developer is going in and they're simply, in addition to putting in their system improvements, they're putting in maybe a water line that has nothing to do with their development. It just happens to cross their development, or maybe we're doing an upsize. Their development requires an 8-inch water line, but we have on our water master plan that being a 12-inch water line, and the city's willing to pay for that increased upsizing. In those situations, our city code specifically does not require those to go to council. If there's money budgeted, a lot of times the city council will put amounts to be reimbursed for water projects. If there's money budgeted, the mayor or someone the mayor designates can approve and sign that particular contract. So we've identified some of those simple development agreements. They're not called development agreements per se. They're called reimbursement agreements, and calls them out specifically as being administrative. And I think, we use the analogy sometimes, if it looks like a duck and quacks like a duck, it's a duck, right? And if it looks like a duck is because our code says it's a duck, right? If it walks like a duck, that means, any regular person could look at that and say, yeah, that's a duck. Or in our case, oh, well, yeah, you didn't need council approval there. That's not legislative. The legislature already, or the legislative body, the council already did their legislative action by appropriating the money for water reimbursements for city improvements in the budget. And all the mayor, and in our case, it's a separate branch of government, In West Jordan, all the mayor and his employees are doing is taking that money approved by the council and applying it to that approved water project, which is more easily spent, may even save the city money, and doing it as part of that project, purely administrative, carrying out the rules, if you will, that the city council already set forth. So I'm glad that Craig brought up that distinction. There might be certain, and I think the question you ask yourself, is this primarily a legislative action or is it solely administrative? Are you making rules, or are the rules already set and you're just carrying them out? And I think if you can argue with a straight face that it's simply administrative, like with reimbursements agreements in West Jordan, then I think you're at least in a much better position if it gets appealed. All right. So, and the last example I was going to mention is the main use of what I would call master development agreements in West Jordan has been in conjunction with a rezone and an increase in density. And so we'll normally have, when that process is complete and worked its way through the Planning Commission, when it comes to the council agenda, there'll be 2 agenda items back to back. And one will be an ordinance approving a rezone, subject to the subsequent approval of the city council and its sole legislative discretion, granting the next agenda item, which is approval of the master development agreement. So rezone approved by the council, subject to the subsequent MDA approval, and then the MDA approval. And when both happen, then those processes are complete, subject to the other terms. And the thought in my mind is, if there's a lot of rulemaking going on in the MDA, and if there's obvious rulemaking, obviously a land use regulation with the zone change that we just talked about, and if the 2 are in conjunction with each other and one's dependent on each other, in my view, that must be all legislative, right? On that level, with those major master development agreements. So in between the master development agreement that I just described and the simple reimbursement agreement that's already appropriated for, there's a myriad of gray in the middle that you've got to decide whether it's black or white and so forth. And then the last thing I wanted to mention here is a land use decision. Let's see, as far as a land use regulation, rather, we said it does not include a land use decision of the legislative body, is what we were just talking about. But it also does not include a temporary revision to an engineering specification. And what we're talking about there is like engineering standards, public works standards, those kinds of things, that if it's just a simple little temporary thing dealing with a small issue, it doesn't increase the cost of anybody's project, then you don't have to go through the full-fledged land use regulation approval process, which means you don't have to go Planning Commission with a public hearing and then to the council. You could presumably go straight to the council. All right, and then you can read through the rest of those questions and practice points. A legislative body, of course, is a city council. It's a county commission. Substantial evidence is really important to support a conclusion. An appeal authority wants to have substantial evidence on the record. And what it means is a scintilla of evidence. It's defined basically in case law and so forth as being more than a little bit and less than a preponderance. So it doesn't have to be most, so to speak. It doesn't have to be, but it has to be more than a little. It's a fair amount, a reasonable amount, right? And that is the main practice point there, is to make sure that your record, your minutes, your documents, your applications, your owner's affidavit, your anything that was submitted to the land use authority initially, that's been submitted to the appeal authority, that you've got all of that available and in the record. Of course, a zoning map, we know what that is. and it is a land use regulation. This also includes overlay zoning maps. So you might have a main zone and then an overlay as well. Overlays are land use regulations just the same. And the question that all of us ask at some point is, do I have to have an appeal authority? And the title to section 109A701 clearly says required, right? You got to have one. And there's three types of appeals. We talked about appeals from land use decisions a lot. We talked briefly about variances. Technically, there's kind of a third area there, appeals from a fee charged. So if somebody says, now, wait a minute, my fee that I'm paying for my subdivision plat appears to be too high. You've got the same subdivision fee for regardless of whether it's 100 lots or one. Mine's simple. Mine's administrative. I'm not even dedicating any land for a road. I've just got this, well, let's say 2-lot subdivision. I'm just trying to carve off a lot of an existing parcel into 2 lots. Why should I have to pay this same high fee? If they want, they can go to the appeal authority. Doesn't mean the appeal authority will grant it, but if there's an appeal authority set up for fees, if not, it's just, if there's only one, it's that authority. In our case, in the city of West Jordan, there's a separate appeal authority as the city council for fees. They could appeal it to the city council, and the council would be the decision maker. Of course, appeals authorities, as we mentioned, don't hear appeals from land use regulations. Those go to district court. And of course, if they want to go to judicial review and district court for a land use decision, whether it's a regular appeal of a land use decision or variance or a fee charge, they've got to exhaust those administrative remedies, including going to the appeal authority to challenge the land use decision in accordance with the local ordinance before they can go to district court for judicial review. You can have, the question here is how many appeal authorities can you have? You can have one, you can have multiple. But you want to delineate very clearly what they have jurisdiction over. Like I mentioned here in the example, in West Jordan, the council is the appeal authority for fee appeals. For conditional use appeals, it's a special conditional use appeal authority, which is a one-person authority. The zoning administrator, technically for certain minor appeals and interpretations, is an appeal authority, and then the Board of Adjustment is designated as currently, and we're looking at possible changes to that. But currently, it's a 5-member appeal authority, Board of Adjustment, for appeals of any other than in items 1, 2, and 3 there, anything else that's an appeal of a city staff or planning commission decision gets appealed to that Board of Adjustment. But the key is to clearly define the role and jurisdiction of each appeal authority if you have multiple ones, each dealing with a different subject matter. For us, the Board of Adjustment also handles variances. And there's all the requirements of what a land use of an appeal authority has to, the requirements of what they have to do, including there's some issues there that you have to deal with if you have a multi-member land use appeal authority. So the main thing you want to watch out for is multiple levels of appeals too. You don't want to have somebody appeal the exact same decision about the exact same issues more than one time. Craig.
I'm sorry, I should have been quicker on the trigger. You mentioned that there are some requirements that go with the board that might apply to an individual. And this is an interesting issue because it's often perceived to be the same thing. The bottom line is the Open and Public Meetings Act does not apply to a single hearing officer.
Right.
The Open and Public Meeting Act only applies to political bodies that make decisions. And clearly the Board of Adjustment is one. And an appeal authority is one if it includes 2 or more members. But if it's a single individual appeal authority, that there doesn't have to be a public notice. It doesn't have to be a public meeting. And the appeal authority, the individual, the hearing officer, can meet and hold an appeal without notifying anybody but the parties and those that are essentially included, which may come up in a later discussion as who might be essential to the conversation. But the critical thing to remember is that there's some flexibility with a hearing officer that wouldn't be available for a panel. And you may, Duncan, want to talk about some of the pros and cons of a hearing officer as opposed to a Board of Adjustment. This might be a good point, and it looks like Wilf's got a point to make as well. Thanks.
Well, yeah, I just want to throw
Will.
something else on Duncan's plate. As Craig mentions about whether you need to even have a public meeting for an appeal process or not. What about a public hearing? It's not required in the code, but I know jurisdictions that do have them, that call for a public hearing for their appeals process. Is that a good idea? Is that a bad idea? Should it be different? Just a question to throw out there and see what you think.
I think those are great questions, Wilf, and I think the answers might be different depending on what the subject matter of the given appeal authority is, right? If it's one that's more germane to necessitating or at least having it be a good idea to have public comment, maybe you're more inclined to require a public hearing. If it's problematic, if a public hearing would be problematic to the type of subject matter, maybe you don't require it for. So I'd say you could either, require it or not require it in certain instances, depending on the subject matter. And like it says here in the ordinance, the appeal authority is the final arbiter of issues, which means that's the city's last decision maker before it could be appealed for judicial review to district court. You don't want to have one member be the same. And that's what I put up in a practice. Well, maybe I didn't put it in a practice point, but you ought to be concerned as if somebody accidentally ends up being in each level of appeal authority, right? Somebody is in the planning commission that is making a land use decision. Then they leave the planning commission and the mayor immediately appoints that same person to be on the appeal authority board. And then an appeal of the decision that planning commissioner participated in is now the same matter that's being appealed to the land use authority. And now he's potentially, a member of both bodies, albeit at different times. It's the same issue, the same matter. And I thought that as I came up with that thought pattern, I thought, what would I do? And that is, I guess, question 53. I guess it was a question rather than a practice point. And my answer to it, at least, is if I was that planning commissioner become appeal authority member, I would recuse myself, right? Or if I was the city attorney, I'd recommend that member recuse himself or herself and not participate at all on that issue in order to comply with this state law, right? So those are the types of things to kind of be cognizant of in case they occur. And then there is this right up above the questions, that subsection E, you can designate if you want certain types of land use decisions to go directly to district court, in a sense, make the district court the appeal authority. You can just say that the land use authority decision is exhausted and there is no internal appeal, and it can go right to court if somebody wants to go out there, if you specifically state that type of land use decision in your city code. So But like it says there, the main practice point do not require multiple levels of appeals for the same issue. You can have multiple appeals going to multiple boards on the same issue as long as they're different subject matter, right? And some of the ombudsman opinions talk about that. All right, and of course you want to have a quorum of members, and that's however you define it in your city code. So a quorum doesn't necessarily have to be a majority. You could have a 7-person appeal authority, and by ordinance define a quorum as 3. But then once they act, like it says in subsection D, they vote on a majority of the convened members. So if you have 3 out of the 7 there, that's a quorum under your code. Then 2 out of 3 that are there need to vote to act on something, right? That is required, that it's a majority of convened members by state law. And so the practice point, define what a quorum is. Don't just assume it's a majority. If it is, great, put it in your ordinance. And then variances, you probably do a whole other different 2-hour seminar just on variances. We're not really focused on that today, but the distinction really is variances, you're literally appealing the city code or county code as opposed to appealing a decision made pursuant to the code. So, and you have to, the appeal authority has to show all 5 of those criteria. Romanets, numbers 1 through 5 there. You have to prove, the burden is on the applicant that applied for the variance to prove to the appeal authority that all 5 of those criteria are met. And this is statutory, right? It's not up to a city, can't change that. The variance criteria are what they are under state law. And like it says there again, the applicant has the burden of proving all the conditions. The variance runs with the land, so a subsequent landowner buys the land, he's got the same advantage if a variance was granted. And the appeal authority may not grant a use variance. Uses of property are exclusively a legislative action. So for each zone in your city code, whatever, maybe it's if the planning commission recommended and then the council approved by ordinance, the land use chart or table, whatever you call it in your city or county, what the uses are that are permitted or conditions in that zone, that's what's permitted. That's what's permitted or permitted with conditions in that zone. And the appeal authority can't change that, right? And then there's this issue of geologic hazards appeals. That's a whole separate special appeals process that you go by state code with. And this is one of the main key points in appeal authority laws, 109704, the time to appeal. And this one has a default. You can pick whatever you want. You can pick 10 days, you can pick 30 days, you can pick 45 days, you can pick 60 days. But if you don't pick a time to appeal, the default, you can't pick less than 10 days. So if I said something less than 10, that's not possible. But you could, in theory, pick 10, 30, 60, 45, whatever you want, anything that's 10 or more. But if you don't pick something in the absence of something in your code, then it's 10 calendar days to appeal. In West Jordan, it's 15 days to appeal. We had a typo in our code where it was 15 everywhere except for one place it said 30, so we fixed that. Now it's 15 everywhere. But make sure if you have multiple references, either have just one reference and have them all cite to that single reference, or if you have multiple references, make sure they're all consistent. Because since we've seen in some of these rules, and we'll see in some of the opinions, that if there's any ambiguity, it gets construed in favor of the land use applicant. So in our case, if we had one reference to 30 in our code, it was 30 until we amended our city code and made it 15, which is what we intended. So, and then the burden of proof is really important. The appellants, The one that's appealing the decision, the land use decision, has the burden of proving that the land use authority erred, that they made an error, that they did not apply the facts correctly to the land use regulations. Yeah, Craig.
Well, and just to emphasize this point about the burden of proof, particularly with relation to variances, I know that many of those attending today may be particularly interested in the variance process and the burden of proof on those 5 key issues. Duncan, would you be willing to scroll back up to the, in your materials, to the questions that have to be addressed in a variance? It might be worth, there you are.
Mm-hmm.
The appeal authority can only grant a variance if, and then the question is, what does that mean? Unreasonable hardship, and special circumstances, and substantial property right. I mean, you make the point about the burden of proof. The applicant for the variance has the burden to establish each of these by substantial evidence, and that means something independent of public opinion,
right?
Something that and it, as a hearing officer, and I do this for eight jurisdictions, this gets a little dicey. Sometimes it's easy for me to say, well, I don't have any court opinion or anywhere else that someone's held to be your issue to be a substantial property right. And we know there are some. The right to use your property for some viable economic use is a substantial property right. The right to have actual reasonable access to your property is a substantial property right. And the question is, what beyond that? The optimal use of your property, the highest and best use of your property, may not be a substantial property right.
Right.
What are your thoughts on that, on those issues, and how the folks attending can be concerned about processing variances?
Well, yeah, and it's depends on the fact pattern, right? I mean, there's all kinds of different things that could come into play. It's not just legal precedent. Sometimes, like you mentioned, it might be certain kinds of facts. It might be not a full-fledged traffic study, but it might be maybe you hired a traffic engineer to prove something dealing with a traffic issue. I think a good example of what might be required in a specific instance is a case I handled as a one-person appeal authority for a small town in northern Utah a number of years ago. And it was a situation where it was kind of a triangular shaped piece of property. If I remember correctly, it was bounded on one side by a UDOT highway, on another side by a river with a house right in the middle on the other side, big house. And on the third side, it was maybe not quite a sheer cliff, but it was a really high cliff all the way along that side. And somebody wanted to own that parcel and wanted to develop it as an owner, land use applicant. And there was a ordinance, a provision in that city or town, I think it was the town's code. And it said no, they didn't call them cul-de-sacs, but no dead-end streets anywhere in the city. That was a citywide provision in their code. And unfortunately, UDOT would not allow more than one access along their highway. So there was no way to kind of do a U-shaped access and egress, only one way in. And there was no way to do an access across the river because you'd have to literally go right through the house on the other side. And that's just not going to work. And then, and that's obviously somebody else owned that house. And then obviously Mother Nature said, no, a road just doesn't go up a super steep, sheer incline. And in fact, the far surpassed the city's slope requirements on our road, right? So they appealed the ordinance to the land use authority, which was me. And they came with a fair amount of information. They came with some information. Hey, here's our correspondence with UDOT saying we're only going to grant one access. That's it. That's all you're getting. And then they showed some drawings showing the elevations, a photo, and then it goes up 1 foot every 2 feet or whatever, right? or and then or 1 foot every foot, I don't know. And they provided on all three sides documentation showing that it was either legally or physically impossible to have a road more than one access other than the one along the UDOT highway, and therefore it was legally and physically impossible to comply. And this was a little easier, right? Because it had such extreme facts. But that the thought in my mind was, what is the evidence, right? And I thought, oh, okay, yeah, the letters and everything from UDOT, okay, yep, all right, there's all the elevations and everything. Yep, there's the pictures. Yep, there's the house right on the other side of the river. To me, I felt like they met all 5 of these criteria, right? Literal enforcement of the ordinance would cause an unreasonable hardship, because instead of what a lot of times it is, oh, yeah, you can develop it not as much as you wanted to. Here, it's like, no, can't develop really at all, right? Or maybe they can just put one house instead of several with a cul-de-sac. And as I went through all those criteria, I'm like, yep, special circumstances. Yep, that's the only way you can really enjoy your property. That's not a self-imposed hardship. That's just UDOT and Mother Nature. And there were a couple of provisions I found that it would on the general plan issue, and substantial justice. I just thought, wow, a guy ought to be able to put something there other than just one house on 5 or 6 acres, right? Especially when all of their zoning provisions, including the zone it was in, would have allowed for at least 6 houses instead of just one, right? So at any rate, that's maybe a little bit of overkill, but it kind of gives you a feel for, I think most variances though are more complicated and hard to decide, and harder to figure out what the necessary documentation is, right? That's what you're referring to, I think.
Sure. But the appeal authority, the code specifically says it's a quasi-judicial entity. And those words I'm not sure in many cases what the distinction is between an administrative decision and a quasi-judicial decision. But what the code is saying, of course, is heightening the due process issue and heightening the burden of proof issue. And obviously, when a person comes in to get a subdivision approval, it's their burden to show their subdivision complies with the ordinance. But here that's even restated and heightened. So a variance simply can't be given if a person hasn't established that a substantial property right is involved, that it's an unusual hardship, that it's not self-imposed, and that the issue relates to the property, not to the owner and the owner's preferences, but the specific way that property is different than others in the neighborhood, because the variance process is meant to allow that property owner to enjoy the same use of the property that others enjoy. So, I just thought it was worth emphasizing that this is where the rubber hits the road, and the appeal authority not only has to make a reasoned decision, but they simply have to show on the record what the evidence is to support that and what legal conclusions they've come to. So that it fits right in with what you're saying in this particular part of the code. Thanks.
Mm-hmm. Yeah, so due process we've been talking about, that's fair notice, fair hearing. I usually say if you're questioning whether or not you should give notice to somebody, just give it. Always err on the side of giving extra notice, better notice, more accurate, more farther in advance to more people. And if you require yourself to do it in your own city code, certainly, definitely do it, right? And then the scope of review is basically when it goes to the appeal authority, does the appeal authority just look at the record that the land use authority created, or do they look at it from ground zero, de novo, new all over again? Is what you want to make sure of in your ordinance. And then You should always have substantial evidence in the record for each essential finding of fact. And what the appeal authority is really focused on, and this is the error standard 4A, is determining the correctness of the land use authority's interpretation and application. Did the land use authority appropriately apply the land use regulations, or apply the fact pattern to the land use regulations? Did they apply that application to the regulations appropriately? And in fact, not just appropriately, but according to the plain meaning of the land use regulations without reading anything additional in. Did they accurately do that? If they didn't, there's an error, and the appeal authority should overturn the land use authority. If they verify that the land use authority did not act in error and they did everything properly according to the plain meaning of the regulations, then they should affirm that decision of the land use applicant or of the land use authority. Wilf.
Well, see, this is where it gets into the issue of if you hold public hearings on appeals. Most of us who've dealt with public hearings over the years, you know that mainly what you get in a public hearing is a lot of opinion, not a lot of facts usually. And so is it appropriate to have and hold a public hearing? It's not required by state code. Some jurisdictions do require it in their local ordinance. It's really something to think about, because what do you really get out of a public hearing that serves as a basis for making the kinds of determinations you were just pointing out?
Well, I think that's a great comment, Wilf, and I think it's a balancing test, right? Is it helpful to get that additional information, or is it just increasing public clamor? The other downside to a public hearing sometimes, I think, is what Wilf is alluding to, is that if this gets appealed to district court or higher, a court's going to look at, did you solely look at or look at too much the comments of the public, as opposed to, did you focus most of your effort on the actual record that you were creating? And sometimes, even though an appeal authority is focused on the record and the evidence that really matters, sometimes if there's too many public comments on appeal, someone could argue, no, Your Honor, the appeal authority focused too much. In fact, I think he's focused solely, or they focus solely, on the public as opposed to the evidence. And that's something that, as a practitioner, you don't want to have occur, especially if that information provided by the public is not helping create that record. So, but whatever decision the appeal authority makes, it's final. That means you've exhausted your administrative remedies. That means it's a done deal, so to speak, unless somebody files, as this next part of the code talks about, an appeal. Technically, it's a petition for judicial review with the district court within 30 days, right after the final decision, which can be defined in your code. It's the written decision, or whatever date, however it's defined in your city code as far as the date of the final decision. Like I say, it's the default is that's the date of the written decision. If you don't define it, then there's 30 days from that point for somebody to apply for judicial review in district court. Otherwise, they lose that opportunity. And in subsection B there, what the court's looking at, they're going to presume that final land use decision by typically the appeal authority is not arbitrary or capricious or illegal. Which, if you've done if a land use appeal authority, if an appeal authority has done a good job and created a record, they've got a really, really good chance of it being upheld as it goes to district court, as long as there's nothing illegal, unconstitutional, legally discriminatory, or, as it says here, arbitrary and capricious, that the decision just doesn't seem to match the record and so forth. And then enforcement, we refer to briefly. There is, at least currently in the code, this distinction between a land use decision and enforcement by a city. They're two different things, get appealed two different ways. I mean, that might be a broad generalization, but if there's an enforcement issue, especially if it's building permits, you want to take a close look at this section. And like I say, you want to strongly, as a practice point, consider having a code enforcement process and a code enforcement appeal authority. And the city can, or county can have penalties for these as well. Which brings us to the ombudsman opinions. And you'll notice that the first three, and we'll just cover those briefly, we might not get to the rest. I want to get to at least one of the appellate court cases, but the first three are all in Park City. And you might wonder, why does Park City get so many? Well, it's not anything to do with Park City other than the fact that they, in addition to their regular land use code, they also have a lot of historic, they have a special historic code, historic design review code. And if you've ever been to Park City, you've seen the awesome Main Street area that they have. And that's because of this historical code. They have certain historical buildings have to maintain certain design standards, look a certain way, be a certain colors, whatever it might be. And so a lot of times when somebody submits an application, they are having to comply with the regular land use code, but then also this historic design review code. This first one, advisory opinions are not like going to court. This is when someone wants an independent special office that's been set up called the Property Rights Ombudsman's Office to kind of weigh in and give their legal opinion on an issue where they haven't been happy, so to speak, with what the city's land use authorities have done. In fact, maybe, Craig, you served as the very first property rights ombudsman years ago. Can you give everybody here like a 2-minute synopsis of how it was set up and what it's used for, the Property Rights Ombudsman's Office?
Those who know me will joke or will laugh at your suggestion I could do anything in 2 minutes.
I'll make it 3.5.
So there was a showdown at the legislature in 2005, I guess it was, 2006. And the agreement was that the ombudsman could resolve land use disputes by advisory opinion, and this avoided the creation of more legislative enactment, imposition on city discretion. So we started it in 2006, and the idea is that one party or the other to a dispute could be one of three: the city, the applicant, the property owner, that is, and the neighbor, or even some other perhaps. Anyway, they go to the ombudsman, raise an issue. It's informal. If the person who initiates it wants to pay $150 fee, then the ombudsman will enter a written decision. And the process is very much like an appeal authority would act, and you can learn a lot from these decisions, these opinions that are written on how an appeal authority would view things. So it's great that Duncan's using these. They very modest cost, takes a few months usually. The ombudsman will listen to both sides, back and forth, exchange documents, and then the opinion will show by substantial evidence how the decision was made. And a great format, to use. You don't usually have to be as extended in detail as the ombudsman's opinions are, but if you do, then you've really done a great job as an appeal authority.
Wow, I think that was 3.5 minutes or less. My wife always jokes about me taking too long to say something, and I always tell her, why say something in 20 words when 100 would do just fine. So, but at any rate, what I tried to do here is summarize multi-page ombudsman's decisions in about 1/2 to 3/4 of a page each. The first one is the Lawrence Meadows and Park City advisory opinion. This was one that deals with the issue of having different appeal authorities, and if they're duplicative or if they become duplicative or successive appeals, if there's different issues going to different appeal authorities. But this one, somebody was just trying to put a garage beneath their home in one of these historic houses in the historic area. And so it had to comply with the regular land use and historic design review codes. The main issue was you couldn't do this in an area where there was a slope greater than 30%. As they went through the process, they realized, oh, the slope's only 21%, so you don't actually need a conditional use permit. But because there was a conditional use permit hearing, then the neighboring owner appealed, right? Because it can be the landowner, city, neighbor, some other property owner. In this case, the landowner was happy. Great, I can do it. There's no disqualification by the slope. City's okay with it. Yeah, it meets our code. But the neighboring property owner appealed to the appeal authority on multiple grounds. But 2 of the 7 grounds fell under the jurisdiction of the Planning Commission acting as an appeal authority, and the other 5 fell under the jurisdiction of the Historic Preservation Board, acting as an appeal authority. If I remember correctly, I think it was staff that was acting as the land use authority. Could be wrong, but so staff was the land use authority. 2 issues get appealed to the Planning Commission as appeal authority. The other 5, Historic Preservation Board as appeal authority. Of course, the complaining party, the neighbor, said, no, there's state law says you can't make me go through 2 different appeal authorities, 2 different levels. The city said, no, we're not making you go. We're only making you go to 1 level for each type of issue. 2 of these issues go to the 1 level of the Planning Commission. The other 5 go to the 1 level of Historic Preservation Board. We're not sending you to multiple levels for the same issues. And the Ombudsman's office agreed with that and issued the opinion that way and said, nope, they're not duplicative, because if the 2 different appeal authorities are deciding completely or reviewing completely different issues, then that does not violate the 2 appeal authority rule. The funny thing about this one was that this neighboring property owner did a great job of going to the Ombudsman's office, but he forgot to file an appeal. He forgot to appropriately appeal everything from there, and so his issue became moot. But so the practice points there is ensure that each issue raised on appeal is before the correct appeal authority. In this case, they did it properly. This is a good example of doing it right, but make sure you don't do it wrong. And as a city, I think, or a county, has an implied responsibility to help the applicant go to the right appeal authorities, right? So if the applicant is coming saying, hey, I want to appeal this matter, okay, great, but you need to take these to this authority, this appeal authority, and these issues to that appeal authority, and help the applicant, especially if it's not easily distinguishable. And then go to district court within 30 days. Don't forget that just because you're going to the Ombudsman's office, if you have an appeal that needs to go from an appeal authority to district court, make sure that you don't miss whatever the rule might be there that's applicable. And then, yeah, like I say, make sure that the appeal authorities really are not dealing with the issues that they shouldn't be dealing with, that the other appeal authority is dealing with. The second one out of Park City is this advisory opinion 130, Krevling versus Park City. This is one, and you'll see a lot of I feel like a large percentage of the cases that go to the Ombudsman's office for advisory opinions deal with conditional uses. And this one, again, in Park City, there was an individual that owned a vacant lot on a steep slope, wanted to build a home. It was allowed by the code, but he needed a conditional use permit. And in this instance, it was the Park City Board of Adjustment that granted the conditional use permit. But it was also in the historic design district. So he had to get approval from them. The applicant did, because it was on Main Street, one of those historic areas. But the Historic Design Board rejected the owner's application because the building's footprint, height, and front steps and so forth exceeded the code. Then the owner sought a conditional use permit as to those issues, and then the owner appealed both denials to Third District Court. The court upheld the decision, except as to the height of the staircase requirement. And then the city closed the owner's application and gave him notice of 10 days to appeal. And that's one thing that we need to be really careful on all sides of this. If you're the city, if you're the land use applicant, if you're a neighbor, once the city closes an application, that triggers the appeal period, right? Whenever the city makes a written decision, or whenever they take an action and any kind of a land use decision, and closing an application counts as a land use decision, which triggers that appeal period. In this case, it was 10 days in Park City. So the owner, like years later, 2 years later, after the Park City changed its code, and under the new code, he would comply just fine with all the city's requirements. And so the owner made the argument, well, wait a minute, so I'm vested then. I should have vested status because my application now conforms with the requirements of the code. Therefore, city, give me my, let me move forward with building my house. And but the issue that the Ombudsman's office dealt with is what is the key point in time where you have to comply with the city's code? And that's the time of the initial application, right? And at the point of his initial application, he did not conform with fully with the code. So he did not have a vesting. So he couldn't move forward and build his house based on that past application. And the key points are, upon closure of a application, make sure you give notice to the applicant of their right to appeal, which apparently they did in this case. The city did a good job of doing that. Unfortunately, the applicant didn't appeal that closure of the application. And then make sure that the changes to land use regulations can't give you a retroactive effect, right? It's only those laws in effect at the time. But the thing that comes to my mind is as I read that through and think about it, the thought is, well, why doesn't the land use applicant just file a new application under the new law that he complies with, right? And I suspect he just didn't want to pay the new set of filing fees. I don't know. But that thought came to my mind. If I was his attorney, I'd say, Mr. Client, let's go file a new application. And then he could, nothing prevents him from, as one of the types of appeals we talked about, is appealing a fee. Why not appeal the fee and say, I don't think I should pay a full set of second fees. Maybe I should have a reduced fee because it's the exact same subject matter. And maybe the appeal authority on that issue agrees that you don't have to pay a full 100% second fee. And then the third advisory opinion from Park City, the advisory opinion 104, Jeff Love in Park City. This is one where a gentleman owned 2 lots and portions of 2 others. Another one where he had to comply with the land use code and the historic preservation code. There was an issue of having he sold one of the lots. There was an issue of having an easement to connect one to the other. Then it was determined that the one house was too close to the property line. Then there was something to comply with the ordinance that either require to get an easement or do something else. The neighboring landowner, even though he was a friend, apparently wouldn't grant that extra easement. So the person who ended up requesting this advisory opinion says, I think I'm just going to move the house and that'll comply with the code. And so at any rate, he was denied the ability by the city to move the house. And if I remember correctly, the decision was basically, no, you could have gotten your friend if you would have tried harder, give you that easement, even though we really had tried and really couldn't get it. And so they read between the lines instead of looking at the record as it is and the ordinance as it is. And the ordinance basically said, if you can't do this, you can do that. And if you can't get the easement, you can move the house. And you can't read between the lines as you're applying a code provision and say, well, I don't think he tried hard enough. It's like, no, the code doesn't say anything about trying hard enough. It just says if you can't get the easement, you can move the house. And so the Board of Adjustment did not allow him to move the house. The applicant applied for an advisory opinion from the Ombudsman's office, and they opined that their opinion was, even though it's not the effective law, right? A lot of times people do treat them as such, or at least it's a good telling position of where you're at. And in some instances, if you ignore the ombudsman, you pay attorney's fees. So you really should pay attention. But in this case, the ombudsman's office, as they issued their opinion, said that the Board of Adjustment was in error. And what they really should have done is just looked at the plain language and interpreted it in favor of the applicants and just required what it required. Does anybody have any questions on those 3 Park City advisory opinions? Or Wilford, Craig, did you want to jump in on any of those? If not, has anybody submitted a question or message at all?
No, we haven't had any. And in the interest of time, I just didn't want to hold you up. We certainly would look forward to hearing from those about those Court of Appeals decisions.
Okay, so let's move there then. It's page 18 in your materials. The first of the 2 Utah Court of Appeals decisions that I've placed in your packet here is called the Fuja versus Woodland Hills decision. And as most people know, that the regular trial court in Utah is called the district court. And that's where if a land use appeal authority makes a decision, as we talked about before, within 30 days, someone can appeal a decision to district court, the regular trial court, for judicial review. And then for further appeal, if somebody doesn't like the district court's decision, they can appeal to the Utah Court of Appeals, or in some instances to the Utah Supreme Court. These 2 decisions are actually the Utah Court of Appeals. This Fuja opinion, and there may have actually been an advisory property rights ombudsman advisory opinion on this or a similar matter, but this is as it came forward to the Court of Appeals. And it deals with the issue of the time to appeal and the issue that we were talking about of the distinction between a true appeal of an actual decision of a land use authority versus the appeal of a code enforcement, right? Or enforcement action. 2 completely different things. And even though that's, as we mentioned, changed back and forth a little in the state code, at this point in time in 2019, arguably they were 2 separate, at least according to this opinion, 2 separate types of actions. And now that the legislature made the change they made, at least in state statute. There are two different types of actions, which leads me to believe that the appellate courts and the legislature watch each other closely, right? And sometimes the state legislature codifies and put in state statute some of the opinions of the or decisions of the appellate courts, and they codify them in state law, or every once in a while, maybe they codify something different if they didn't like those decisions and so forth, or vice versa. I think the Court of Appeals is doing its best job of looking at the plain meaning of the state statutes and applying it. So the fact pattern in this case was this is in Woodland Hills city or town, and they issued a residential building permit to owners of the lot adjacent to the Fuges. So I'm going to call them the Fuges and the neighbors. And then, so the Fuges, and it might be pronounced Fujas, but the Fuges, their attorney sent in a series of letters to the city, and they weren't officially requests or applications or petitions for the city to do anything. They were just letters, not official appeals, right? And one had saying, "Hey, city, I don't think the neighbor of my client's house that's going up, I don't think they meet the maximum height requirements of your code." Another letter that says, "Hey, I think the slope's off." Another letter that has another 13 different things that were alleged code violations. And then finally, after the third letter, Fuji's attorney he actually files an actual appeal, right, to the Board of Adjustment, saying that the city code, but instead of appealing the actual land use application, in this case a building permit, instead of appealing the building permit, the actual application or decision made on that application, he asked for the city code to be enforced, which is that other process, right? Wasn't as clear in the state code, the Utah code at that point, but he applies for this appeals to the Board of Adjustment to enforce the city code. And then the Board of Adjustment issues a decision, and it says, "Hey, we don't have authority to deal with code enforcement appeals. This does not constitute a land use decision, so we cannot act on it. And oh, by the way, your appeal was untimely because our code requires that you appeal within 45 days, which is a lot more than most, right? And you missed the 45 days." And his argument in return, Fuja and his attorney, was that no, the city didn't give us an actual letter or written notice that started the 45-day period. We didn't receive actual notice. But the city says, "Well, yeah, but you had constructive notice because you saw that the house being built. In fact, we have all these letters from your attorney saying that, so at least by the date of the first letter of your attorney, you knew then, constructive notice, that what was going on." And that it started the 45-day clock to appeal. You missed the time period. And of course, Fuja did file within the 30 days the petition for review with district court. And the city filed a motion for summary judgment, just basically saying, "Hey, Judge, you should rule in our favor because all the facts and that everybody agrees to, the law clearly has to be applied in our favor, and we shouldn't even be here." And the district court judge granted that city's motion, finding that inaction by the city cannot form the basis of a land use decision review, and that they should have gone through section 10-9A-802 and done an enforcement action, but they couldn't, in a sense, use the enforcement process they had to use the appropriate enforcement appeal procedure, not the land use decision and land use appeal process. And then, of course, the Fuges appealed it to the Court of Appeals. And their argument there was, well, it was a decision by the city to allow departures from the permit. They were equating the city allowing certain things that they didn't think were appropriate under the code, as they equated that, or trying to equate that, to being a decision. And the court says, well, nice try, but it held that the appeal section of the state code does not apply when they do not formally, they can challenge any decision made under the Land Use Act, but they can't use it to enforce a decision pursuant to it, that they are two separate types of things. And that is, I think, then what the appellate courts, the state legislature are kind of struggling with, is defining if this is a separate process, how does it get fleshed out with its appeal authorities for code enforcement and so forth. And like I say, as a good practice, I think it's always a good idea to, if the, unlike the land use appeal process, where it's very clear what you can and can't do with an appeal authority, not as clear with enforcement appeals. I think any time that the state legislature is silent as to exactly what a city can do under the Hutchison rule, basically the gray area, as cities were authorized to fill in the gaps, so to speak. I think it's a great practice for cities to flesh out their own code enforcement process, including their code appeal or enforcement appeal process. To put you in a better situation. But the other thing I gleaned from this case, which is right up above where it says the key practice points, is where it mentions that, like I say, the constructive notice, that counts the same as if they had actual notice. And there are situations where, even though you didn't have actual or constructive notice, you may have had, there might be an exception for exceptional circumstances if in situations where somebody did not give, let's say the city did not give accurate information, or in fact, if they give misleading information, which caused somebody to not file an appeal, which they otherwise would, there is an exception in those exceptional circumstances for someone to argue that 45-day appeal window should not, or whatever the period is adopted by the city, should not apply if that constructive or actual notice was misleading in some exceptional way. But in this instance, with the Fugia case, that the Court of Appeals specifically found there were no exceptional circumstances justifying a departure from that appeal window. So they affirmed the district court's decision. So you can read through the practice points on your own there, but I think they're good ones dealing with constructive and actual notice. And like I say, it's a saving grace sometimes for a city if they didn't give actual notice, if they can prove there was constructive notice. But like I say, normally a city wants to err on the side of providing the best possible notice that they can. The last thing that I'll cover is the other Court of Appeals case. It's Staker versus Town of Springdale. And before I get into that case, the appendix, which we won't cover at all, I just wanted to make a kind of give a disclaimer. I attached as appendix materials some selected provisions of the West Jordan City Code. My disclaimer is this: we've updated them consistently, including over the last year or so. They're not perfect; they're still a work in progress. If you find a typo, or if you find something that's not 100% adhering to the principles we've talked about today, I'll chalk it up to we're in the process of making it the best we can. So, but certainly it could be used as a checklist or as a source of options. But like I say, we've worked quite a bit on it. But the Staker versus Town of Springdale appellate case, this is a good one. This is one where another conditional use permit type case. Springdale apparently had it where Planning Commission would recommend to the council, and then the council would be the actual land use authority for conditional use permit. This particular person, Staker, applied for a conditional use on his 3-acre parcel of land near Zion National Park. He wanted to put a parking lot in. It was a neighborhood, was mainly residential. Wanted to put a small parking lot kind of in the middle of everybody else's houses. It was a conditional use, apparently hadn't been done before. In their case, they did have a public hearing. The Plan Commission recommended a denial of the application because the surrounding properties could not be adequately screened. And the town council, based on that recommendation, denied the application following their public hearing. They also held one. And they made some findings that the parking lot would unreasonably interfere with the lawful use of surrounding properties because of increased traffic and so forth, and that you'd need additional municipal services like restrooms. And then they relied on some conditional use standards in their ordinance, which is always a good practice with conditional uses. And they created an awesome record, right? And they had all kinds of things in there. And so Staker appealed the denial to the appeal authority that the city had. The appeal authority affirmed the denial because there's nothing clearly erroneous. That's the standard of the appeal authority, right? Correctly applied the facts to the city code. And it was based on correct interpretation of the law. There was an issue that came up about potential mitigating conditions that the applicant said that they didn't really look at, but the appeal authority said, no, it's clearly in the record. They looked at potential mitigating conditions. Another argument the applicant made was they needed the consent of the neighbors, and it was like the response was that no, it was just the allowed public opinion, but there was a lot of record, and didn't look like they were focused on the public opinion as much as they were the rest of the record. And the district court, when it got appealed there, they denied the petition with prejudice, so they couldn't bring it back again. Basically confirming the findings of the appeal authority that under the error standard, there was no incorrect interpretations of law. There was substantial evidence in the record, and they did not solely focus the initial authority, and the appeal authority did not solely focus on public clamor. That they listened to them a little bit, but they was pretty much focused on the record, and there were adequate findings. So with that in mind, you can see the practice points and so forth, but the two thoughts I take away are that maybe what they could have done better is they could have put evidence in the record that showed the 5 or 6 or 7 ways that they could have screened, but none of them worked, so that they could show there really was no way to find a condition that mitigated the adverse effects, and maybe had a small traffic study to show the trips per day, something that they could measure with. But I hope you have a chance to finish reading through the other ombudsman legal opinions, the rest of the packet. Appreciate everybody being present today, and I'll turn the time back to Craig.
Thank you, Duncan. Great presentation and lots of information. Please do read the materials in more detail. And just as a parting thought on the Staker case, you might not have catch what Duncan just said. There's a duty on the applicant to counter the evidence, and one of the judges disagreed. There was a dissenting opinion, and the point was made in the decision. The applicant should have stepped up and showed by substantial evidence that he was mitigating his his negatives, that they said the record was deficient on the applicant's part. So, word to the wise. Okay, I think we're done. Let me just mention, we're going to revise and update these materials with some of the conversation that went on. We'll do that for your benefit. The advisory opinions for the ombudsman are available in the Utah Land Use Library. You go to utahlanduse.org, click library, and there'll be information there. All the advisory opinions are annotated, and more information about appeal authorities. Also, more information about appeal authorities in this book, which is free online at utahlanduse.org in the library, chapter by chapter. It's available at Amazon. It's not too late for Christmas giving. And we also want to refer you to the Land Use Academy of Utah, Luau, which has training materials for the appeal authority. Lots of resources, lots of help. And again, thanks for your attendance. Thanks to Duncan for all his work. And we certainly appreciate the funding from the Division of Housing and Community Development, Department of Workforce Services. Thanks. I think that ends our video today. Appreciate your attendance.